on this case? I mean, to people like you and I think a lot of other people out there, I mean, for us, it's kind of open and closed. We're not exactly sure what the jury is dealing with, but one of the developments that we learned this afternoon is that the jury had asked for additional copies of pages 1 through 6 of the judge's instructions. And those pages, as we understand, have to deal with the self-defense privilege and also Joseph Rosenbaum and intent to kill. Does that indicate anything to you? What is your takeaway from that?
Well, it indicates what they were thinking about in that moment. In other words, that was very soon after they retired to deliberate. So their focus very quickly is on self-defense. And the debate that happened yesterday before final arguments, I think, is germane to this discussion because the defense team was asking the judge to make an instruction that said, listen, even if you find all the elements of a crime is present, if you find that Rittenhouse acted in justifiable self-defense, you're done, and you don't have to consider anything more about that count. And so he gave them a shortcut and an appropriate one, and one that was correct under the law of self-defense, to say, look, you don't have to consider lesser included offenses. You don't have to go any farther. If you find he acted in justifiable self-defense, you're done. And so that gave me some indication that they may be looking to take that shortcut on each of the 5 counts.
Ooh, interesting, because I know some people, there was a lot of speculation from non-lawyers, people like me. I get a little nervous if it's not, you know, I have an expectation when I'm paying attention and watching everything very closely to a trial, which I don't always do. And so normally I don't have such a hardened opinion, a formed opinion like this. But from all the video and the testimony, you know, it makes it, a lot of people were speculating, gosh, if this goes on longer, does that indicate a hung jury? Is that what that's indicative of? And I know that I'm asking you to look at a crystal ball, but how long do you anticipate this going? And does that signal maybe a hung jury or something like that to you the longer this goes on?
Well, I think it's true that the faster they come back, if they in fact reach a unanimous verdict, the better news that is for the defendant, for Kyle Rittenhouse. The longer they go, it does certainly add to the likelihood of a hung jury, but I would go several days before I get over concerned about that. And the reason for that is because this is a 12-person jury. And a lot of states, including my Indiana, in state court have gone to 6-person juries. One, because it's hard to find people to serve as jurors. And secondly, because it's hard to get 12 people to agree on anything, including the lunch menu, much less a lot of complicated facts involving testimony and evidence from a lot of different sources. So the fact that there are 12 people that have to reach a unanimous verdict, it just means it generally takes some time. And some juries too, and I've seen this in my cases, where they go days and you start getting nervous, you start thinking about a hung jury. And then in a lot of cases, judges will let you talk to jurors after a trial is over. And it turns out all they did is they decided, because they wanted to be thorough and they wanted to be responsible jurors, they decided to take each piece of evidence and each witness and go through them and talk about them and evaluate and discuss how they felt about each piece of evidence, and then turn to the legal issues and the jury instructions, then apply the law to the facts and then reach a decision. So sometimes juries just decide to be very deliberate and I think very thorough, and that's not a bad thing. And I think that's not a bad thing in this case. They also easily could get caught up in a discussion, for instance, of sort of the changing theories of the prosecution in this case. I watched all of the prosecution closing argument yesterday, and I had watched the opening statements as well. And what was interesting is, and the defense pointed this out, in the opening statements, the prosecution never talked about provocation. And that is the legal argument that if you provoke unlawful action against you, you lose the right to self-defense. It was interesting that that never came up in the opening statements But suddenly it was really the crux. It was the main argument, the principal argument made by the prosecution. And that tells the jury of, hey, this trial didn't go the way I thought it was going to go. The evidence didn't come in the way I thought it was going to. So now I've got a secondary theory that I'm going to latch onto and try to sell you on that, even though that wasn't one of my main talking points when I outlined the evidence for you, which is the purpose of an opening statement. And that's a little bit of a concession. It doesn't mean they can't win on that. And you heard, and I've even heard you talk about this recently, Dana, about, well, you know, if he brings the gun, he loses the ability to claim self-defense. Well, it's not bringing a gun. That you and I would be in trouble on the use of self-defense, because
it's an attack of all concealed carriers for sure,
absolutely,
or anybody
absolutely.
who carries.
Yeah, but what he's trying to do is he's trying to shoehorn the idea of bringing a gun to a situation like this protest, this riot, into the legal argument that is a correct statement of the law. It's true here in Indiana where I practice. It's true in Wisconsin that if you provoke the unlawful action, then you can't claim self-defense. So now simply having a gun in that context is provocation. That wasn't the theory of the prosecution going into this case, but suddenly it's their main argument and closing argument. I think jurors will take note of the fact that that's suddenly a new, if not a new argument, a new focus for the prosecution, and that doesn't, I think, bode well for how they evaluate their own case.
And to your point on this guy, talking to our friend Guy Relford, a Second Amendment attorney, he's handled cases like these. You hit upon something incredibly important with that in those closing arguments, because the idea that simply possessing a firearm, especially I hear this a lot with people who criticize those who open carry, that lawful open carry, even a rifle slung across someone's back, is somehow by itself a provocation. And I think that's such dangerous territory, because we're hinging the validity of a natural right on whether or not someone finds it provocative. How is that sound legal argument?
Well, no, exactly. And, you know, the bullet, the PowerPoint slide that he put up, the one bullet point said, you can't claim self-defense if you brought the gun. And I read that, and I would have loved to have been in the courtroom to see the faces of the jurors, because I would really hope that at least a few of those jurors seeing that bullet point had to do a double take and say, what? You know, lawfully carrying a firearm is somehow now something that makes me relinquish the ability to use force in self-defense. My goodness, why would any of us carry a gun if that were true? Obviously it's not, but it shows a little bit of desperation, if not a lot of desperation in my mind. And I thought that was very telling yesterday. It was something that I was pointing my finger at my computer screen saying, you just shifted your theory here, which means you're not in love with your own case, the way you outlined it at the beginning and the way it came in through even witnesses and evidence that the prosecution put in.